Good day to you. This week's tutorial focuses on the regulation of managing agency contracts in terms of the Act, more particularly in terms of the prescribed management rules made by regulation under the Act. The tutorial is designed for both managing agents and for trustees. I consider this an important issue, and I note that it has come up recently in the discussion forum. Let's first give you a quick overview. We're going to touch on, and I'll introduce it and just give some context. Then we will go to the appointment of the managing agents, the duration of the contract. We'll go in some detail into the termination process, and finally we'll end off with looking at managing agent records and rights, and very finally a criticism that I have of the current structure. Right. The Act does not mention managing agents at all. Their appointment and all aspects of that are dealt with in the prescribed management rules. The prescribed management rule 46.1 is one of those that cannot be substituted by the developer on opening of the register, so it is likely to appear in its prescribed form in the rules of most schemes. Let's have a quick look at the context. Section 39.1 of the Act provides that the body corporate's functions and powers must be carried out by trustees, but Section 38A allows the body corporate the power to appoint such agents and employees as it deems fit. Prescribed Management Rule 28 repeats various aspects of the Act, for example, that the trustees must carry out the body corporate functions. There it repeats 39, that the body corporate must do what is necessary for the enforcement of the scheme's rules and for the management of common property. So that's really just the context in which the managing agent's appointment operates. Let's look specifically at that appointment. Firstly, who, when, and how. In terms of Prescribed Management Rule 46.1, trustees, not owners, appoint a managing agent. They can do so at any time, and that would require a trustee resolution. Clearly, you can't just have a chairman or an individual trustee going out and entering into the contract. It must be a resolution of the trustees properly taken and minuted. Now, they must appoint a managing agent if this is required by registered mortgagees with 25% or more of the units bonded to them. It doesn't specify that this must be in writing, but this would be the normal way in which a request or a requirement of this sort would come. And how do you calculate the 25%? It's in number of units. The trustees must also appoint a managing agent if they are required to do so by owners in general meeting. A pure ordinary resolution is sufficient, and this is analogous to the Section 39.1 situation where trustees are doing things that they're told to do by the owners in general meeting. The contract must be in writing in order to be valid. Now, how long does it last? It lasts for an initial period of 1 year, and then there's an automatic default renewal for a year at a time with effect from the anniversary date, unless the body corporate has notified the managing agent that this won't happen. So, for example, if the trustees conclude a contract with a managing agent on the 31st of December 2010, or before that date, so that it runs from that date until the end of December 2011, the contract will continue until the end of 2012, unless the trustees notify the managing agent during 2011 that the contract will expire at the end of that year. And there's also another possibility. During the contract, it may be possible, the contract itself may include a term that it can be terminated at any time on 1 or 2 or 3 months' notice. If this is the case, then it is quite clear that in entering into the contract, the trustees have told the managing agent that this automatic rollover won't apply in an unlimited fashion, that they reserve the right to give a shorter period of notice in order to terminate. Now, how does the termination process work? Well, the trustee's notice of termination can be authorized either by a trustee resolution or by a majority resolution of owners. And this provision is designed to counteract what was becoming a nasty practice of managing agents tying in bodies corporate, saying, well, you can't terminate my contract unless you get a special resolution of owners or a unanimous resolution of owners. I saw in some cases. There is certain mandatory content in regard to cancellation. PMR 46.2a requires a clause that provides that if the managing agent is in breach of the contract terms or does anything that would justify termination of the contract, then the trustees can terminate the contract without notice, and in those situations the managing agent has no claim for damages. There is also a requirement that there be a termination on demand of owner or bondholder. So PMR 46.2b, c and d cater for this situation. If the managing agent is in default, as I explained in the previous slide, then any owner or mortgagee can demand the trustees cancel the contract, and in that case the owner or mortgagee must give security and indemnities to the body corporate for all costs involved in that process, and the trustees are not obliged to in fact take steps to cancel the contract until those securities and indemnities are given. There must, in terms of PMR 47, be a mandatory automatic revocation. So the managing agent's contract must include a provision that it will terminate on the provisional final insolvency, liquidation or judicial management of the managing agent, person or company. If that person is convicted of an offence involving fraud or dishonesty, or if by way of a special resolution the owners decide that that contract must be terminated. But in that latter case, then the managing agent may still have the right to claim damages. Let's look at the records that a managing agent must keep. Firstly, he must keep full records of administration. Now that really means everything that is given to him he must keep and keep safely for the body corporate, including those documents that he prepares for them. He must also report to the body corporate and to all bondholders who have notified the body corporate of their interest any matters that in his or her opinion detrimentally affect the value or the amenity, that means the ability, the facility of the common property in any sections, their ability to be used for the purpose for which they are designed. Then let's have quickly a look at managing agent's rights. Firstly, a managing agent in terms of Prescribed Management Rule 49 is entitled to notice of trustees' meetings. He or she is entitled to attend trustee meetings, but must leave if he's asked to. That right of attendance is subject to the trustee's consent. And the trustees could, in advance, say to a managing agent, look, we're going to be dealing with sensitive information today. We don't want you to attend the meeting. And then a managing agent is also entitled to copies of all minutes of trustee and owner meetings, so that although he may not be or she may not be entitled to be there, they will certainly know what has gone on. I have a few criticisms, and they are fundamentally that the prescribed rules are not the place to regulate contracts between body corporates and managing agents. If you look at section 35(4) of the Act, the rules bind the body corporate, the owners of sections, and any person who occupies a section. Now that won't normally include a managing agent. So in my view, these provisions, which perhaps need revision so as to be slightly clearer in their wording, but they should be in the regulations under the Act, in the regulations proper, not in the prescribed management rules. Thank you very much for watching this Paddocks Club tutorial, and I hope to hear from you in the discussion forum.